Good morning, everyone. Yeah. So thank you for coming for this event on a Saturday morning. I know that's it's a tough call, but thanks for showing up. The reason we're having it on Saturday was because we wanted to fly in lawyers from outside Delhi to contribute to this discussion, because conferences in Delhi tend to be only about Delhi lawyers. And we think it's important to have, a wider conversation on judicial reforms with lawyers from outside Delhi. By way of introduction, my name is Prashant Reddy. I head the judicial reforms team at the Vidhi Centre for Legal Policy. This commercial courts project is part of our Jaldi program, which is Justice Access Loading Delays Initiative. We've set ourselves some very lofty goals on reducing pendency and judicial, court backlogs in India, which I doubt we'll actually achieve in the near future, given the scale and enormity of the problem. So we are primarily supported, the Jaldi program is primarily supported by the Tata Trusts, who've been very generous with their support for us. On one of our focus areas in judicial reforms is to look beyond the normal narrative in that pertains to the judicial reform space in India, which is that we need more judges, we need more funds. There is a more serious problem with the way the judicial system is working, which isn't getting enough attention. And even our colleagues at Daksh, we have Leah Verghese here from Daksh, and even they work on similar areas. They're trying to look beyond the regular problems which judges seem to flag as the main cause for judicial pendency. And this project today that we'll be discussing, our commercial courts report, which has been authored by Vaidehi and Ameen, who are sitting here, we've tried to take a deeper look into what exactly is impeding the efficient disposal of cases. And I hope that in the discussion that follows, we can go a little deeper into some of the systemic issues of facing the judicial system, and try and perhaps identify new areas of research that could be the focus for all of us in the future. With those few words, I'd like to end my introductory address. So the format of the event will be, we'll start with a presentation by Vaidehi and Ameen, followed by 3 rounds of discussion, which I will moderate with the panel. And we will try and squeeze in some time for Q&A if possible. But if that isn't, we'll take maybe perhaps questions at the end at around maybe 1:15, 1:20, after we finish all 3 rounds of discussion. Thank you again for coming. Vaidehi, please, please come and start.
Good morning. Thank you again. I think we cannot thank you and appreciate enough you showing up in such large numbers on a Saturday morning. So the presentation is broadly split into 2 parts. I will be talking more about the objectives of this legislation as well as its legislative history. And Vaidehi is going to delve deeper into the data analysis and the actual impact evaluation that we've conducted. So this act was introduced in 2015 by the NDA government. The stated objective, which is there listed in the statement of objectives of the bill, says that it aims to expedite the disposal of high-value commercial litigation. But the bigger idea behind introducing it becomes abundantly clear when we take a look at the parliamentary debates which were focused on this legislation. The law minister, Sadanand Gowda, back then, categorically says that the sole aim and objective of this legislation is to boost India's ranking in the ease of doing business. The idea behind this boost was it will improve our image internationally as an investment destination, and sort of fits into the larger set of economic reforms that the NDA sort of came to power into. The act in itself in 2015 is also a culmination of a decade-long debate on the issue of setting up exclusive commercial courts in India. This whole debate started... One second, sorry. Yeah. So this whole debate starts. There are two phases to this legislative history. The first phase is essentially prior to the NDA government, when the erstwhile UPA was still there, and even before that, in 2003, the Law Commission came out with its 188th report. This report focused a lot on this growing spate of international criticism against the Indian judiciary, where judges, particularly in the US and the UK, were questioning the capacity of the Indian courts to deliver justice effectively. And one of the key reasons, which is not unexpected, was this inordinate delay that continuously plagues any litigation that sort of ventures into the Indian legal system. And the problem was that these courts had started appropriating extraordinary jurisdiction and hearing civil cases which were typically supposed to come to Indian courts, and they were justifying it on this doctrine of forum non conveniens, which is essentially that the delay renders a litigant without an effective remedy and therefore makes the forums in India inconvenient to pursue justice. The Law Commission, in a very typical format, suggested that you set up these specialized commercial divisions in the high courts, which will expedite the process and deliver justice faster, and also dispel this growing international perception against the Indian judiciary. Now, I just want to plug in here that this is also happening, if you think about it chronologically, it's happening around the time when, through the 80s and the 90s, there's been a perception in the judiciary that specialized tribunals are some kind of a silver bullet that will remedy the ills in the system and expedite litigation. In hindsight, I think it can be effectively argued that this has not really worked out to be a successful experiment. And in some cases, like, there are serious questions on to the necessity of these specialized courts or specialized tribunals. So, from the Law Commission's recommendation, the UPA government tabled the first iteration of the Commercial Courts Bill in 2009, which was solely proposing commercial divisions at the High Court. This met with a strong opposition from both the left and the right parliamentarians. And from like the challenge was posed on two prongs. The first was that this bill sort of established 5-star, 7-star courts, which would privilege and prioritize richer litigants over poorer ones. And the second prong, which was actually spearheaded by Mr. Arun Jaitley as the leader of the opposition in Rajya Sabha, was that you are further encumbering something which is the slowest rung of the Indian judiciary, that is the high courts. They do not have either the means or the resources in terms of manpower or infrastructure to cope up with this additional workload. And transferring cases from the district courts to the high courts will prove to be ineffective and counterproductive when you're not actually tackling the larger systemic challenges. So, all these allegations and challenges resulted in the bill eventually lapsing in 2013 and not really coming to any fruition. So this is where the second phase of this debate sort of ventures into, and I will again go back to what I said at the outset, how the BJP came to power in 2014 and led the NDA to victory on the promise of revitalizing the Indian economy and reinvigorating our economic policies. It promised to do so through series of legislations, including the Commercial Courts Act. The other ones included the Arbitration Act amendments and introduction of legislation which was going to counter black money and money laundering. All this was supposed to be one composite package which was going to reform the economy as well as improve our ranking in the ease of doing business index. So in 2015, again, the BJP referred the 2009 bill to the Law Commission to study, and the Law Commission basically drastically reworked the draft and overhauled some of the setups. For starters, it created commercial courts at the district level in addition to the commercial divisions, and it also created the commercial appellate divisions. Now, here's the bifurcation between a commercial division and a commercial court. Commercial divisions were created only in 5 high courts which exercised original civil jurisdiction. That is at Himachal, Delhi, Madras, Calcutta, and Bombay. And everywhere else, commercial courts at the district level were supposed to be the courts of first instance for pursuing litigation. The other thing that it did to sort of retain the exclusivity of these fora was to set a minimum value of 1 crore to ensure that litigation below that value is not really flooding these fora and therefore like just again clogging the system. So this bill, after the law commission, the law commission annexed a draft bill containing all these things, and also made some significant proposals to amend the CPC specifically for these commercial courts and introduce new provisions like summary judgments and case management hearings. And these were then annexed to the report as a draft bill, which was then taken up, tabled in the parliament, where, like I said, the key point that was harped and reiterated was the need to improve India's standing internationally, attract more foreign investment, revive our economy. And to do so, the means to that end was deemed to be this improvement in the ease of doing business index. This so the bill was originally passed as an ordinance, and subsequently it was also sent to the standing committee, where the standing committee did not really make any significant changes to it. One thing that was suggested was that to ensure that even like extreme high value commercial litigation is actually coming to these courts, they proposed that you increase the minimum valuation to 5 crores, which was not really implemented in the final version of the act. In December 2016, this law was enacted by the parliament and came into effect from the 1st of January in 2016. The interesting part here is that in 2018, this legislation in less than 3 years has already witnessed a significant amendment to its processes. One of the key things that they've changed is now reducing the minimum valuation from 1 crore to 3 lakhs, which again is a bit contradictory given that the whole debate so far has been targeting exclusive high value commercial litigation, and now they have essentially opened the floodgates to any kind of commercial dispute which can come up to the value of 3 lakhs, and it can be allowed to come to these courts. So it again begs the question, do we actually need exclusive courts, or you just introduce these amendments to the CPC and allow your regular civil courts to carry out these adjudications rather than designating specific commercial courts? The second thing is very interesting. So like I said, the whole point of ease of doing business has been at the center of this debate, at least for this present NDA government. In 2017, there was a task force that was constituted by the Ministry of Law and Justice to look into why India's ranking, despite improving in the overall index, is not improving in the enforcement of contracts index, which is primarily focusing on the justice system. So this committee, if you look at their minutes, which are publicly available on the website of the Department of Justice, clearly shows that in 2017, at a much belated stage, there is this realization that the World Bank is actually studying courts at the district level in Delhi and Bombay. And both these cities do not have commercial courts under this act at the district level, because they both have high courts which exercise original civil jurisdiction. So they have commercial divisions in the high courts and not commercial courts. Now this is a problem because you have effectively pushed through a legislation on this gigantic policy issue of improving your ranking in an international index, which is questionable in its own self, in its own right. But at the same time, you've not even understood the methodology that is being adopted to actually formulate this ranking. And that understanding only emerges like subsequently 2 years later, when they then decide that, okay, we're going to amend Section 3, delete the proviso, and create commercial courts at all districts, irrespective of whether the high courts exercise original jurisdiction or not. So this whole process cumulatively, and like we've extensively dealt in the first chapter of our report critiquing this whole process and the policy basis of this legislation. But this process shows that lawmaking is far from perfect. It's an imperfect creature, completely ridden with politics, and it's not essentially just advancing systemic reform and ideas which make sense, but in a lot of situations it is haphazard and hasty, and that is problematic. So now I'll pass on the mic to Vaidehi, and she can delve deeper into the more implementation and quantitative aspects of our study.
So I'm dealing with something that I really enjoy, which is a lot of the quant stuff. So the first thing we're going to be looking at is Section 17. So Section 17 was introduced in the Act. So high courts are required to publish data on their websites on the 10th of every month. This data is basically going to be constituting of the number of cases that have been disposed, number of cases that are pending, and the number of cases that have been instituted. This provision was introduced because the Law Commission felt that there was inadequacy of data and it was really difficult to determine what the impact of the Act would be and why the Act, how the Act would be implemented in all of these courts. And that's why this provision was introduced. So after the Section 17 was introduced in the 2015 Act, in 2018 they also introduced another set of rules in order to supplement this provision, and they were called the statistical data rules. Under this provision, not only were they supposed to record the number of cases, like a blanket number of cases, they were also required to bifurcate these cases. So as you can see, there are suits, applications, appeals, writ petitions. All of them, there's a requirement that they categorize, these cases be categorized and the information be recorded under this provision. So the high courts are maintaining data, but they're not just maintaining data for the commercial divisions or the commercial appellate divisions which are at the high court level. They're also required to maintain this data even for the commercial courts which are at the district level. Should I switch one of these off? Okay. So the schedule provides us, so this is the schedule from the statistical data rules. The schedule provides us the categories under which the data is required to be maintained. So this is the number of cases pending, institution at the first, and this is pending at the end of the month, and disposed. So these are the three categories, pending, institution, and disposed. There is another additional category, which is the average number of days taken. However, none of the high courts that we analyzed were actually recording this data. Since the Act was introduced to expedite the process of deciding cases, if we had this particular data, it would be easier for us as researchers to determine whether the Act was in fact effective or not. So after analyzing the websites, we realized that only 8 high courts maintained this data and 3 high courts maintained part of this data. I'll explain what the difference between this 8 and 3 is in the next slide. And we realized that 12 courts were in complete violation of this provision. So there seems to be a lot of indifference in the high courts to even adopt some of the provisions of this Act, which is unfortunate because this is something that was mandated under the Act. So in addition to checking the websites, we assumed that maybe these high courts were maintaining this information but not publishing it on the websites. So we filed RTI applications in addition to sort of scraping the data. So the next slide is slightly overwhelming for me. Okay. So this is the data that we were able to record. As you will see these red boxes, I'll just explain the key first. As you will see, these are the red boxes. So these are the 8 high courts that I was talking about. So 1, 2, 3, 4, 5, 6, 7, 8. These high courts were maintaining the data. 8 high courts were maintaining the data. As you will see here, these letters here signify the months. So this is November, December of 2015. And this goes on till November of 2018, which is the time period for which we analyzed, which was a 36-month time period. As you will see, the Delhi High Court here is the only High Court that maintained this data throughout, which is for all the months that the courts had been instituted. And so when you look at, say, Madhya Pradesh, for example, this is partial data on the website. Madhya Pradesh maintained this data, but only maintained it through a drop-down menu. They did not maintain it as per the format given under the Act. So if you wanted to analyze this information, it would be really difficult because you would have to go per district, per month in order to see the number of cases that have been instituted, disposed, and pending. So this is the data that we obtained from the websites. As a follow-up, the RTIs that I was talking about, the blue sort of columns tell us the information that we received through RTI applications. The response in RTI applications is like indicator not just of how the Act had been implemented, but also in terms of the transparency that the courts had in providing us this information. So as you will see, Delhi, for example, provided us the information for all the months that they had uploaded the data. So all of these, so Tripura, for example, gave us that information, but they only gave us like the number of pending cases, which was again partial information. So in the previous slide, as I mentioned, the word partial here means that it was not for all the months. This was section 17 disclosures. So on the basis of the information that we had obtained, we tried to compare all the courts and the different trends in all of the courts. And that's the variation. So this is the information that we obtained from section 17 and the RTIs. As in the previous slide, you would have noted that it's not a continuous line in all of these courts. So there is, like for Delhi, for example, we have data for 35 months. Bombay, for example, we have data only for 1 month. So the time periods that we've used for so the next slide will tell us that all of them are averages. So the time period that we've used for all of these averages is not equivalent in all of these cases. And I wanted to let everyone know that's a part of our methodology on the basis of the fact that we were not able to obtain a lot of the data. So the first slide is on the number of cases instituted under the Act. I'll just take you through it slowly. So this is the number of months. So we started looking, our analysis starts from April of 2017. So April of 2017 to October of 2018, that's the time period at which we have analyzed. So these are, let's month-wise. There's another thing which is, so as you will see, this is CD, and as you will see here, it's CC. So that's commercial division and the commercial courts. So Delhi, for example, had a commercial division. It did not have commercial courts because it was not permitted. So you only have data for the Delhi commercial division. Once the commercial courts started being introduced, Delhi started maintaining data even for the commercial courts. The same is the case with Bombay. Has a commercial court, and then you have has a commercial division and the commercial courts. As you will note that these lines are not always, they're not complete, they're only partial in some cases. It's because data was being maintained only for that short period of time. Ameen has told you about the 2018 amendment that had been introduced. So as you will see here, the amendment was introduced in July. So as you will see here, the amount of data that started being maintained. So this is before the amendment, and this is the data that started being maintained after the amendment. So the number of lines here increases because data started being maintained by these courts a little more than it was before. So let's do a couple of the numbers. So as you will see, so this is Gujarat. This is Gujarat. As you will see, say this is 26. So Gujarat in May 2017 had 26 cases that had been instituted. You look at the numbers in Delhi, for example, this is 260 cases. So there is like quite a variation between the number of cases that have been instituted in Delhi vis-a-vis, say in Gujarat or in Madhya Pradesh, which has very small numbers, which is like at 4 or around 5. But the numbers in Delhi and Bombay continue to be sort of similar. So you can see it's all in the 300 range, and Bombay also has numbers in the 300 range. So it means that commercial litigation is taking place only in certain commercial centers and not everywhere equivalently. So after the commercial division, after the act was amended, commercial courts started being introduced in these two places. And you will see that in Delhi, after the pecuniary value was reduced from 1 crore to 3 lakhs, the number of cases shot up. So this is around 1500 cases. So like from the 305, which was the 1 crore limit, they started being like the number of cases shot up to 1500, which is a significant increase. Bombay, on the other hand, did not see a significant increase. As you can see, the numbers are not very, like in comparison to Delhi, they're not very high, which meant that Delhi, in comparison to the whole of India, was producing greater amount of litigation above 3 lakhs than the rest of India, which means that the number of courts that we would think need to be established under the Act need to be varied on the basis of the number of cases that have been instituted in all of these locations. Okay. As I was saying that all of these were institutions, the next slide talks about how all of these are the number of courts that have been instituted, like number of courts that have been constituted in these states. So say for example, I don't think you're able to see the gray, but all of this is gray. Okay, so if you can see, Kerala is marked in gray. It's because Kerala does not have a commercial court. It was not mandatory for all of the states to have commercial courts. The high courts could notify if they felt there was a need. So Kerala decided that there was no need. And there were no commercial courts. Manipur here also does not have a commercial court. So the numbers, I'll just explain the key first. So the numbers here, for example, 1305 are the average number of pending cases. The slide before this was the number of cases that have been instituted month-wise, and this is an average number for the time period that I was mentioning before. So Tamil Nadu has an average number of month-wise average number of 1305 cases. And out of the 32 districts, commercial courts have been constituted in all 32 districts. Say Tamil Nadu, for example, commercial courts have been constituted in all the districts, Telangana in all the districts, in Delhi it's all the districts, in Maharashtra it's in all the districts. And these are commercial courts number. So in Maharashtra and Delhi, these are not commercial divisions. We are not looking at those commercial divisions. It's only commercial courts. So as you can see, some states are constituting commercial courts in all of the districts. Some other states, on the other hand, say Odisha, for example, and Karnataka, for example, have commercial courts only in a couple of districts. So they've selected the number of commercial centers and they've constituted courts only there. So another thing to remember or sort of note is the number at Delhi. So as we'd seen in the previous slide, Delhi had 1,500 institutions. The number of pending cases is 14,244 in comparison to, say, Maharashtra, which has 770 cases. So this is again another example of how commercial litigation is taking place in only some centers vis-a-vis others. It is given that these numbers tell us that there might be a need to constitute courts on the basis of the number of pending cases. So if you were to constitute courts in all 11 versus you were supposed to constitute, like if you were constituting courts in all 33, this is pretty disproportionate. The numbers are pretty disproportionate. So maybe there is a need to constitute more courts in Delhi as in comparison to Tamil Nadu, for example. The Karnataka numbers might suggest, so when 3 courts are being constituted, if an individual wanted to file a commercial case in a district that was not their home district, where there was no commercial court, an individual would have to travel a sizable distance in order to file their case. So another sort of determinant of constituting commercial courts would have to be sort of the geography of that place. Otherwise, it would also impact the litigant's ability to file cases. Okay. So we spoke about the pending rates in the previous slide. We spoke about the institutions in the slide before that. And this is the slide regarding disposal rates. So disposal rates are understood to be the number of cases disposed vis-a-vis the number of cases pending. So if there are 100 cases that are pending, if 10 cases have been disposed, it's a percentage of 10. As you will note, none of the states here or none of the locations or courts here have any numbers that are in double digits. So it's a very small number of cases that are actually being disposed of by these commercial courts. If there was expeditious disposal as the Act had intended, these numbers would have been significantly higher, which means that there is some capacity issues that are happening in these courts which prevents them from disposing of these commercial cases. So one of the example was in Bombay High Court, where a writ petition had been filed by one lawyer at the Nagpur bench stating that there was a lot of capacity crunch. I'm just going to read out a very small section of the number of cases of the workload that this judge has. So this was one judge who had to dispose all commercial cases, and the writ petition notes that the work was being distributed amongst as many as 18 courts of civil judges senior division and 55 courts of civil judges junior division before the introduction of the Act, and this was being transferred to one single court of a district judge. In addition to this workload, the same judge was also designated as a special judge dealing with cases under the Prevention of Corruption, apart from hearing all regular session trial cases, criminal appeals, and criminal revisions. Which means that these judges who are dealing with these cases are not just dealing with cases under the Act, they're also dealing with a lot of the other workload. And in this particular case, it was 18 and 55 judges, the workload of 18 and 55 judges were being transferred onto one judge, which is just simply impossible for an individual to dispose of cases under this. So the number of disposals tells us that there is definitely a capacity crunch in all of these courts. There are not a lot of Delhi lawyers, but if we were to look at the roster for Delhi, which is similar to the rosters in other courts, we'll realize that these judges who are dealing with these commercial cases are not solely dealing with commercial cases. They're also dealing with a lot of other cases, writ petitions, other company matters, which also means that there is another capacity crunch that's happening. Okay. So the first part of our analysis was a pan-India analysis. This is the second part of our data analysis. So we looked at 3 courts, which is Delhi, Mumbai, Vadodara. And we looked at 150 cases in all of these courts, so which was 450 cases in total. We went through the order sheets of all 450 cases. There are a lot of interns who hate us. And we did this analysis. We did this analysis since the act was instituted in all of these courts till December 2018. So the order sheets were from since they were instituted, which is in Delhi from November 2015. Because the act was notified in June and July in Vadodara and in Bombay, the cases were from June and July in Vadodara and Bombay, which means that 2.5 years or 3 years would have passed since, like, when we are checking the status of these cases. So the time period that we've sort of chosen is from when they were instituted to December 2018. Okay, this is the percentages of the cases disposed vis-a-vis cases ongoing. So as you can see, only 35% of these 150 cases in Bombay were being disposed. 65% of them are still ongoing. The numbers are sort of slightly higher in Delhi with 69 and 31. Vadodara performed the best with 79 and 21. And there are caveats to this that I'll explain in the next slide. Which means, but this slide sort of means that there are some practices that perhaps are happening in the Bombay High Court, which is changing the amount of cases that are being disposed. And these are practices that we need to identify and remedy if these courts were indeed going to increase their disposal rates. So you have Mr. Seth, and I think Mr. Seth can help us out when we do our roundtable on what these practices probably are. So as you had seen in the previous slide, Delhi has, say, a disposal rate of 69%. There's a reason to it. Delhi is right here. If you can see, 45 is mediation and settled, and 17 is withdrawn, which is around 40, 50, 60. Around 60% of the cases that are being disposed of in Delhi are either being withdrawn or being settled. So these cases would probably have reached the same conclusion even if the act had not been introduced. So the number of cases that were probably being adjudicated by the court are only a very small section. So 34% of them were being adjudicated by the court. And if the act was being effective, it was only probably these 34% of the cases that would have been impacted. These cases would have probably been disposed of in a manner even before the act had been introduced. And we saw in the previous slide that Gujarat was the best performer. There's a caveat to that too. Gujarat, if you can see, 26% of them were uncontested or it was on account of non-prosecution, and 27% were transferred, which means that about 50% of the cases in Gujarat too have other reasons that cannot be attributed to the act. So transferred cases essentially means, so when the act was introduced, cases were being instituted under the act, and cases were also cases that were commercial cases also got transferred as and renumbered as commercial cases. So once these cases were renumbered, because they were thought to be commercial cases, the court decided that they were in fact not commercial cases. So they were again transferred out of that court. So a large number of cases that were supposed to be disposed in Gujarat were actually transferred, and the other half sort of was uncontested on non-prosecution, so those cases got disposed of anyway. So these numbers that we saw, which were really promising numbers in Delhi and Vadodara, also have caveats to themselves. Okay, so the amount of time taken to dispose commercial cases, I'll just be slightly quick about this. So we looked at the amount of time that was being taken. So under 1 year, we realized, and these are absolute figures. So 150 is our total. These are absolute figures. And this is the time taken to dispose. So this is not all 150 cases. It's only the cases that have been disposed. Say 63 cases were being disposed under the year. It's important to remember that this 63 also includes cases that were settled. And it's also important to remember that in Delhi, there's a lot of IP litigation that happens in Delhi. And these cases tend to be disposed much quicker than other cases because they tend to be settled. So one of the contributors to the disposal in Delhi is also the fact that there are a lot of IP cases. This is the number for when it was 1 to 2 years. The numbers sort of in Vadodara are greater, but this could also be attributed to the method in which they were disposed. I was talking in the previous slide. Okay, So one of the reasons, if I go back here for just a bit, so we were talking about these number of cases that were actually adjudicated by the court. So we thought we should maybe analyze the number of cases that are actually going to trial, because the act was introduced to expedite the process of trial. So we tried to analyze if how many cases were in fact actually going to trial. We realized that a very small percentage, so these numbers in light pink, they're percentage figures in, this is supposed to be gray. Gray and red are absolute figures. So these light pink numbers tell us that only 22% of the cases, 26% of the cases are actually going to trial. The number of cases going to trial is really small. So in Bombay, only 5% of the cases are going to trial, and in Vadodara, only 21% of the cases are actually going to trial. Going to trial means that issues have been framed in these cases. So very small number of cases are actually going to trial, which means that the act has been introduced, in fact, for a very small number of cases in the first place. Okay. So we also try to determine what was actually causing the delay in all of these cases. What was it that was in all of these cases that were being adjudicated, that were being settled regardless, in cases that are both ongoing and disposed, what were the causes of delay? And summons sort of came across as a major cause of delay. So time taken for summons, we analyze the time taken for summons. Sort of this number tells us that this is around three months, slightly more than 3 months. Say 70 cases, and these are also absolute figures. 70 cases in Delhi were around the 3-month mark. 54 cases in Delhi were around the 3-month mark. The numbers, as you will see in Bombay, are much smaller. It's because the order sheets, when we read the order sheets, a lot of information regarding summons was not available in the Bombay order sheets. So the data set that we had for Bombay was much smaller. And so these numbers, the 3-month numbers, you would like, the 3-month numbers are fine. It's these numbers that go beyond the 3 months that are slightly scary, which means that they're at the time taken for summons to be issued and the process of summons to be completed is in fact very high. And so when an act, such a procedural reform such as the act was introduced, there is no way for the act to have remedied this by default. So there are other additional systemic issues that need to be addressed, and there are other systemic issues that need to be addressed that a procedural act like a procedural reform like the act might perhaps not be able to address. So there's one specific thing that I want to sort of bring your attention to is this number. So more than 365 days. 12 cases have taken in Vadodara have taken more than 365 days for the process of summons to be completed. Out of these, there's an asterisk here because out of these 12 cases, 8 of them, the process of summons is still not completed. Okay, because we had sort of better data for Delhi, we tried to do a sort of more granular analysis. And as you will see, sort of the 3-month mark, beyond the 3-month mark is where the problem we would think sort of arises even more. We realize that 40% of the cases take more than 3 months for the process of summons to be completed. So a sizable number of cases, the process of summons is taking a very large amount of time. So I think Daksh has also done a study on the amount of time, along with Vidhi has done a study on the Prashant's telling me to wrap up. The amount of time that it takes, as summons is being an integral part of the amount of time that it takes to sort of dispose of cases. Just some anecdotal evidence. And as you will see in Delhi, for example, there's a case that has 955 days have gone in the process of summons to be completed. It took 11 hearings and the summons has still not been completed. In Bombay, and I'll just come back to Bombay, in Vadodara, 8 of the 32 ongoing cases, summons is still not completed. So sort of summons as a cause of delay keeps reiterating itself. The oldest pending cases here are in Delhi from 2005, from Bombay from 2009, and Vadodara from 1972. These numbers are much before 2015. It's because cases were being renumbered, so all of these cases have been in the system for longer. Sort of, we were trying to think about what was it in Bombay that was causing a lot of causing a very small number of cases to be disposed. We realized that 66% of the ongoing cases had a hearing a year ago. So the last hearing that they had was a year ago. So we did our analysis in 2018. So they had it in 2017. And 22% of those cases had hearings 2 years ago. So which means, I mean, there is a case management system under which like cases are given, cases are listed in these courts, and on the basis of that it turns out that a lot of cases don't even get a hearing for a large amount of time, and these are practices that are so systemic in nature that an act such as like commercial courts would probably never be able to remedy. Okay, this is probably the last slide. Probably. Okay, this is the indifference and the underutilization of key provisions. There are two key provisions that were introduced in the Act. One was case management hearings. These are basically hearings that that the court has to conduct before the process of trial begins, providing a schedule of how the amount of time it's going to take for the evidence to be done, the amount of time it will be taken for the oral hearings to be done. We realized that of all the 300 cases, both in Delhi and Bombay, 0 cases had any case management hearing. All of these are commercial cases, and case management hearings are mandatory under the Act, and 0 cases has any case management hearing. Of course, there are a couple of cases when you do case law research, you'll realize that there were case management hearings that were being conducted in Delhi, but of the sample that we studied, none of them did. In Vadodara, the numbers were slightly higher at 28. So summary judgments are applications, are basic. It's an application you can file with the court saying that we don't need to go to the process of going through our evidence, but we can just in a summarily fashion decide on the case. And out of the 450 cases that we analyzed, none of them were summary judgments. These numbers for the case management hearing says that perhaps the bench itself does not take the provisions of the Act seriously. And the summary judgment means that the provisions of the Act are probably being underutilized by the bar in itself. So concluding remarks, this is the last slide. So we realized that a lot of the Act was introduced, as Ameen has told us, the Act was introduced because of a variety of reasons, but a lot of them don't seem to be evidence-based at all. So Section 17 data, for example, would have provided us greater evidence on what the need was, but we don't have that data. So there is a need to think about bringing about reforms on the basis of evidence. Case management hearings and the number of courts that have been sort of dispersed around India tell us that there's actually been sort of poor implementation of the Act itself, both in terms of the number of courts that are being notified and the provisions being utilized. We also realize that there are a lot of systemic issues, and summons is one of those examples where something like a procedural reform like the Act can't remedy at all. So thank you.
Okay, thank you, Vaidehi and Ameen, for that presentation. You guys went over time. I hope the rest of us can stick to the schedule. But as you can see, they've put in a lot of work into putting this presentation together and doing the research. And as anybody who's worked on judicial reforms in India, I'm sure both Pratik and Leah will testify that data is, it's so difficult to get it from the Indian judicial system, which is why studies like this take so long to complete. Because the poor interns who hate us had to actually go through all the order sheets for 450 cases, and that wasn't a pleasant task. So now, before we start the discussion, let me just do a round of introductions for all the panelists for the audience. Leah over here works with Daksh. As all of you know, Daksh does a lot of cutting-edge work on judicial reforms. Most recently, they worked with the Economic Survey of India on their chapter regarding the judiciary. Thank you for making it here from Bangalore. So Leah has also done some work on commercial courts in Karnataka, which is why we really wanted her here for this session. Swaroop Mamdipudi is a practicing lawyer in the Madras High Court. He does a variety of commercial and IP matters. Mr. Jaideep Verma is one of the leading practitioners in Vadodara on commercial litigation. And since Vadodara was one of the courts that we covered, and it's thrown up some very interesting contrasts to the Bombay and Delhi High Court, which is why we're really grateful for Mr. Verma joining this conference. Mr. Kapoor is a partner at Keithan. He's the sole Delhi lawyer over here. And as all of you know, Keithan is one of the leading law firms in India. So we're hoping he can share